Hello everyone, my name is Lalit Soni and I welcome you all in this new initiative by Drishti IAS, that is Polity This week. As you know that in prelims 2024 there are various questions which has been asked from polity sections. Nearly about 18 to 19 question has been asked from the polity section. Okay, that is nearly 1/5 of the whole paper. Now when we talk about the weightage or when we talk about the questions which are asked by the UPSC, you will see that there is this pattern that there are certain static questions which has been asked from polity section. But if you look at them, so they are having their backward linkages which are attached with the current affairs or the whatever news events which has happened. Okay, so basically what happens is that if there is some kind of event which has happened, let's say there is this you can say election of speaker which has happened and it was in news, so they will be asking a static portion from the speaker's topic. Okay, now this is how it becomes important that you make sure that your preparation is integrated in a manner that even current affairs are basically complemented with the static portion, or your static portion is complemented with the current affairs. Okay, so you have to go for an integrated preparation. Considering that in mind, we have started this new initiative, that is Polity This week. In this we will be talking about the topics which has been in the news from the in the past week, and then we will talk about the static portion which is related to that. Okay, so let's assume that there is this leader of opposition which was in news because recently the Congress has announced that they will be going for the Rahul Gandhi to be the leader of opposition. Okay, now this is the event or this is the news which has happened. Now what we will do is that we will just tell you that why it was in news, and then we will go to the static part of it, that is basically we will talk about the leader of opposition and whatever provisions are there with respect to that. Okay, so that is the idea behind it, so that your preparation can be integrated with respect to prelims, mains, and otherwise also if you are talking about just prelims examination, so current affairs are basically having this close relations with the static part which has been asked in the paper. Okay, so let's start with the first episode of it. What we will do is that we will be discussing the news from the past week, and then we will be discussing 5 to 6 topics, and then we will talk about certain MCQs. Okay, so in this particular episode or episode 1, here we will be talking about the national emergency, then we will talk about speaker, deputy speaker, pro tem speaker, because 3 terms has been in news, then leaders in the parliament, then we will talk about the leader of opposition in Lok Sabha, and then we will go to the twin test in the PMLA. Okay, because recently that Mr. Kejriwal was there in the jail, and that was under the charges of PMLA, and wherein this twin test was in news, so we will talk about that. Then enemy agent ordinance, so that was related to Jammu and Kashmir, it was also in news for some reason, so we will be talking about that as well. Okay, and after we finish the discussion, we will go for a small test or a quiz, so we will be discussing 4 or 5 questions over there which you have to answer in the comment box. Okay, so now let's start. First is your national emergency. Okay, when we are talking about the emergency, that the center will have more power in that. Okay, if there is a threat to the security of the country, okay, so then in that particular cases, president has right to go for the declaration of the national emergency. Okay, there are certain grounds, okay, like war, then we have external aggression, and then we have a particular internal disturbances. In such such grounds, we will be going for the declaration of the national emergency. In the past, we know that there was this emergency which was imposed by Miss Indira Gandhi, our then Prime Minister Indira Gandhi. So she has imposed emergency, and recently what has happened in that, after the new speaker has been elected, and when he was addressing the Lok Sabha, and he has mentioned certain things about emergency or the era of the emergency, because of which this topic was in news, and we will be talking about it now. Okay, so let's talk about national emergency. Grounds for proclamation, as I told you, there are 3 grounds, that is, one is war, second is external aggression, third is basically armed rebellion. Earlier this word was there, that is armed rebellion, but this word now has been replaced with the word that is internal disturbances. Now this particular word was replaced in 44th Constitutional Amendment Act in 1978. Okay, so these are the 3 grounds. One is war, second is external aggression, third is internal disturbances. Now Article 352 talks about this particular kind of emergency. We know that in India there are different kind of emergencies. One is your national emergency, then there is president's rule, and then we have financial emergency. Right now we are talking about the national emergency, which is mentioned in Article 352, and president is authorized under Article 352 to proclaim a national emergency. Okay, Now, President may declare a national emergency even before the occurrence of a particular event. If there are speculations that something will be threatening the security of our country, in that case, President can go for a declaration of emergency even if the event has not occurred yet. Okay, so that is about the provisions. Now, if we talk about certain more things related to emergency, you know that whenever emergency is declared, there is a parliamentary approval which is required. Okay, that is kind of a check and balance which has been established by our constitution. So here you will see parliamentary approval within 1 month after the date of issuance, it must be ratified by the both house of parliament. Now, focus is that within 1 month after the issuance of the order by the president. Second thing is, it has to be ratified by the both houses of parliament. Okay, now what if Lok Sabha is not in session at that point of time? Okay, so if Lok Sabha is not in session or it has been dissolved, so within the 30 days after the new Lok Sabha is assembling or the new session has started, within 30 days you have to approve that particular resolution. Okay, so you know that there is this time which is 1 month. Within 1 month you have to approve it, and if Lok Sabha is dissolved or it is not in session, in such cases, in the next 1 month when it was assembling, that you can go for the approval. Okay, now coming to the next part, that is duration of emergency. Normally, if we talk about, emergency will work or be in effect for the 6 months. Okay, after approval it will be there for the 6 months. Okay, but it can be extended. How? However, such proclamation may be extended indefinitely, with each extension receiving parliamentary approval by a special majority every 6 months. Once these 6 months are over, you can go for the another approval. Okay, then another approval. By that way you can go for the emergency like situations for like indefinite period of time. But for the approval you need a special majority. So that is one, you can say, when we are talking about the emergency and the approval by the special majority, so that is a big task. Okay, so when we are talking about the special majority, that is 2/3, so that is a huge thing. So that is about the duration of emergency. It can be when we are talking about the first approval, it will be in effect for the 6 months, and then if you have to extend it, then you will be taking approvals every 6 months with a special majority. Okay, so that is about the duration of emergency. Now, if we talk about the revocation, how revocation will happen, so president has power in this regard. President at any time, okay, can go for the revocation of the emergency. President may revoke the state of emergency at any time by issuance of a new proclamation to that particular effect. Okay, that is there. Otherwise also, if Lok Sabha is not approving it, obviously then it will end. Third thing is, if Lok Sabha is adopting a resolution by a simple majority rejecting the continuation of the emergency, then emergency will stand revoked. Okay, so now the thing is, Lok Sabha's approval, Lok Sabha's consent is very important over here. Now here you can say Lok Sabha by a resolution, they can revoke it with a simple majority. Now for the approval, when we are talking about the starting an emergency situation, then you need special majority. Then when we are talking about the revocation, then you need to revoke, you need simple majority. So that is a technical point which you have to remember. Now impact on the life of Lok Sabha and state assemblies. Okay, now emergency can be imposed in whole nation or some parts of the nation. Okay, so if it is there in particular state assembly or in the particular state, then there are certain impact on the legislature over there. Okay, or when we talk about the whole nation, then the impact will be on the Lok Sabha. Now actually when we talk about the terms of Lok Sabha and state assembly, that is that 5 years. But if there is a situation of emergency, that term can be extended. Okay, but that extension should be done 1 year at a time. Okay, and after that emergency is ending, within 6 months you have to go for the new Lok Sabha. Okay, so that is there. During a national emergency, Lok Sabha and the state assembly term may be prolonged beyond its regular term for up to 1 year at a time, which can be valid up to 6 months after the emergency has ended. I hope that is clear. Now moving further, impact on the fundamental rights. Now there are two articles, article 358 and 359. These are talking about the impact of emergency on the fundamental rights. Okay, so first we will talk about the on fundamental right, that is article 19. Okay, when we talk about article 19, that is freedom of speech and expression. So whenever there is this you can say issuance of the emergency proclamation is there, suspension of the fundamental rights under article 19 starts immediately. Okay, so immediately the article 9's operation will be suspended when the proclamation of national emergency is made under article 358. Their suspension does not require a separate court order. So obviously when there is a proclamation, which has been made. Now with that particular proclamation, this article 19 of the Indian Constitution will suspend. Okay, so that is one thing. Second is, what about the other rights, other fundamental rights? So there is this article 359. Okay, so in that particular article 359, it is said that during a national emergency, the president is authorized to suspend the right to petition any court for the enforcement of the fundamental rights. So basically here, president will decide which particular fundamental right is to be, you can say, whose enforcement is to be revoked. Okay, so when we are talking about the article 359 over here, so you can say enforcement is delayed basically. Okay, so in that particular period of time, you cannot go to any court for the enforcement of the fundamental rights, but afterwards you can go. Okay, so basically here we are not suspending the fundamental rights. What we are doing is that the enforcement of these fundamental rights is being delayed. Okay, so in that particular duration of the national emergency, you cannot approach the court. Okay, so that is about this national emergency, its impact, how it is approved, how it is, what is the time period with respect to that. We have seen for approval there is 1 month, which is you have to get the approval within 1 month. When we talk about the approval, you need this special majority. When we talk about the revocation, we need simple majority. Okay, so all these aspects which has been covered from the national emergencies point of view. Okay, now we can move to the next news item, which is basically related to speaker in Lok Sabha. Now you know that after the new Lok Sabha has been elected, okay, there will be election of the speaker. Okay, so recently there was this election which has happened. Okay, and the specific, or you can say which is interesting part is that this time they have gone for the election of the speaker. Most of the time speaker is basically chosen or the elected unanimously, but this time there were certain issues. When we talk about the from the opposition's point of view, they have said that if the ruling party will go for the you can say continuation of the convention with respect to the seat of the you can say deputy speaker. Okay, generally there is this convention that deputy speaker will be from the opposition party. Okay, and the you can say opposition parties has said that if the ruling party is willing to give that particular office to the opposition party, then they will support the candidate of the ruling party for the speaker. But if not, then in that case there will be elections. Okay, so there was this contest of election which has been done. Okay, so this is for the, I guess, fourth time in our history that has happened. Otherwise most of the time speaker has been elected unanimously. Okay, because of which the topic of speaker was in news, topic of deputy speaker was in news, and topic of pro tem speaker was also in news. When we talk about the pro tem speaker, most of the time there is this convention that the senior most member in the house will be elected as the pro tem speaker, but this time also that convention was not followed, and because of which it was in news. So we'll be talking about all these aspects over here. So let's start. First we'll be starting with the speaker. Okay, so when we talk about speaker in the Lok Sabha and in the state assemblies also we have speaker. So speaker is basically elected by the house itself after the new Lok Sabha is assembled, and in the first session, in the first 2 days, there will be this oath administration which will be done by the pro tem speaker, and after that there will be election of the speaker. Okay, and in that particular election, if the parties are supporting, every party is supporting that particular candidate, you don't have to go for the election. That unanimous decision can be you can say made over here with respect to speaker. Now speaker is basically a post which is supposed to be impartial. Okay, it should not have any biasness with respect to any kind of political party. Okay, so when we talk about Neelam Sanjeeva Reddy, so he was when he was made speaker, he has given the resignation from his party. Okay, he said that this post is basically impartial in nature, and that is why he has actually given the resignation, and he is the only person who was speaker, and later he was made president unanimously. Okay, so that is an interesting fact you can remember. Now talking about speaker, the constitutional or the ceremonial head of Lok Sabha who preside over the day-to-day functioning of the Lok Sabha. So that is there. And when we talk about what work or the function which is done by the speaker and the deputy speaker in the Lok Sabha, similarly in Rajya Sabha we have chairperson and the chairman and deputy chairman. Okay, so that is there. Now when we talk about the origin of this particular post, so there was this 1990 act, okay, or you can say Montagu-Chelmsford reforms. When this has happened, so in that there was this provision of the president and vice president. Okay, sorry, president and the deputy president. So when we talk about this particular post which was there in 1919 act, So that post was created in 1921. Okay, so in 1921, from the effect of the Government of India Act 1919, so President and Deputy President was appointed. Now with the act, that is 1935, Government of India Act 1935, in that particular act, the post of President and the Deputy President was changed to Speaker and Deputy Speaker. Okay, now when we talk about the Speaker, Speaker and the Deputy Speaker, that election process that is given in article, or when we talk about the you can say appointment, that is basically given in the article 93, and it is by the simple majority by the House itself. Okay, and they are eligible for the re-election as well. Now moving to the election criteria, so he should be the member of you can say Lok Sabha. There is no specific qualification which is given. Okay, and generally it belongs to the ruling party. Okay, so generally this is convention that Speaker will be from the ruling party and Deputy Speaker will be from the opposition party. Okay, now tenure is basically you can say that 5 years, that is with respect to the life of the Lok Sabha. Okay, whenever Lok Sabha is dissolved, now Speaker will be there till the new Lok Sabha is assembled. Okay, so when the new Lok Sabha is assembling, then only he will vacate the office. Okay, so that is there. Now coming to the powers, so he is the final interpreter of the constitution provisions within the House. Okay, otherwise when we see that mostly Supreme Court is the final interpreter of the constitution overall, but the thing is in the House he is the you can say final interpreter. He presides over the joint sittings. Whenever there is a deadlock, to resolve that particular deadlock, we have the provisions of the joint sitting, and he will be the presiding officer of the joint sitting. Okay, and he can adjourn the House, suspend the meeting in the absence of quorum. You know that when we talk about the quorum is basically 1/10 of the total membership. Okay, if quorum is not ensured, then he can go for the you can say adjournment of the House. Now power of casting vote, he will not go for giving the vote in the first instance. Let's say there is a voting in the Parliament, or when we talk about the particular Lok Sabha, so there is a voting in Lok Sabha, and then in the first instance he will not go for the voting, but if there is a tie, then he will cast a vote, that is basically called casting vote. Okay, now he will be deciding on the issue of money bill. Okay, if a bill is a money bill or not, he is having the final authority over here. Okay, when we talk about the removal, so if he ceased to be a member of the Lok Sabha, then he will cease to be a speaker as well. That is one thing. Second thing, he can go for the resignation. Okay, and that resignation is should be handed over to the deputy speaker. When we talk about the deputy speaker will give this resignation to the speaker. Okay, so that is there. Now otherwise there is he can be removed by the effective majority. So if there is a resolution in this regard that speaker must be removed, then there should be an effective majority to remove the speaker. Okay, so that is about the speaker and certain you can say provisions which are related to him. Please remember that article 93 of the constitution talks about the you can say speaker, deputy speaker. So I hope that is clear. Now we can move further with the next. Now we will be going to certain you can say constitutional provision which are there. First is article 73 and article 178. This is related to your you can say appointment of speaker and deputy speaker in Lok Sabha, and article 178 is there for the legislative assemblies in the states. Okay, now moving further, article 94 and 179 respectively talk about the vacation, resignation and the removal from the offices of speaker, and then in the Lok Sabha and the legislative assembly respectively. Then article 95 and 180, that is talking about the power of deputy speaker or other persons to perform duties of office of the speaker if he is not there. Then article 96 that says that when there is a resolution with respect to the removal of speaker or deputy speaker, in that particular point of time he will not be presiding any session. Okay, so that is a very normal logical point, that speaker and deputy speaker not to preside while a resolution for his removal from the office is under consideration. Okay, I hope that is clear. Now moving further to the next, that is basically pro tem speaker. We have talked about the speaker, we have talked about deputy speaker. Now pro tem speaker. Pro tem speaker or the pro tem term means that for the time being or the temporary. Okay, so this term pro tem means temporary. So whenever Lok Sabha is assembling for the first time, whenever Lok Sabha is assembled, so the previous or outgoing speaker will actually vacate the office. Now who will preside over the House? Okay, so at that point of time, president actually appoint a pro tem speaker. He will be presiding the House, and then he will go for the administration of the oath by the members. Then second function will be that he will be actually providing for the, or you can say facilitate the elections of the speaker. Okay, so that is there. So let's see. Appointed by President under Article 95 Clause 1 of the Constitution to perform the duties of Speaker till the election of the Speaker. Pro tem is a Latin phrase which means that for the time being or temporary. Appointed to preside over the sittings of the newly elected House, usually the senior most member of the House, and when the new Speaker is elected by the House, the office of the Speaker of Pro tem cease to exist. Okay, so here we have seen that he will be facilitating the elections of the Speaker. He will be administrating the oath of the new members, and he will be presiding over the new Lok Sabha. Okay, so that is there. Second, when we are talking about he will be the most senior most member of the House, that is the convention. Okay, now recently in the new Lok Sabha, this convention was not followed. There was this member, okay, Mr. Suresh, and he was not given this particular opportunity, and despite being the senior most, he was there for the 8th term, and then the speaker who was chosen, okay, so you must know the name, you can reply me in the comment box. So he was chosen and he was the 7th term MP. Okay, so despite the seniority, he was not given the opportunity. So that is why this office of pro tem speaker was in news. Now moving further to the you can say duties of pro tem speaker, which we have already discussed, so you can go through this. Now let's start with the new topic of discussion, that is related to leaders in the parliament. Okay, when we talk about parliament, there are Lok Sabha, then we have Rajya Sabha, and president is also part of parliament. When we talk about the leaders in the parliament, so one is in the Lok Sabha and then there is a Rajya Sabha. So leader of the Lok Sabha is basically most of the time Prime Minister, and if he has given for the some other person, or he can nominate some other person to perform the duties of that leader of the house. Okay, leader of the house in Lok Sabha. Okay, so that is there. When we are talking about the leader of a house in Lok Sabha, either Prime Minister will be there, otherwise he will be nominating another person. Okay, when we talk about the leader of the house in Rajya Sabha, so there will be a person who will be nominated by the Prime Minister in that particular house. Okay, recently Mr. JP Nadda has been appointed as the leader of the house in Rajya Sabha. Okay, that is why it was in news, so we have taken it. So let's talk about it here. Under the rules of the Lok Sabha, the leader of the house means the Prime Minister or another minister who is a member of Lok Sabha and is nominated by the Prime Minister to function as the leader of the house. Okay, that we have discussed. Now moving further, there is also a leader of the house in Rajya Sabha who is a minister and a member of Rajya Sabha and is nominated by the Prime Minister to function as such. Okay, then he or she exercise direct influence over the conduct of the business. The office of the leader of the house is not mentioned in the constitution but in the rules of the house. Okay, so please remember that constitution does not talk about leaders of the house, but it is there in the, you can say, rules of the house. Okay, so that is enough for the leaders in the parliament. Now coming to the another leader which is there from the opposition's point of view, that is leader of opposition. Okay, now when we talk about leader of opposition, recently there was this news that Mr. Rahul Gandhi will be the leader of opposition in Lok Sabha. Okay, so here you will see the leader of the largest opposition party having not less than 1/10 seats, that is 54. Okay, so that is basically when we are talking about this 1/10, that is the quorum. You remember that? So at least this much number of people should be there, or at least this much number of seats should be there. Okay, so if they are having less than 54 seats, okay, then there won't be this particular provision of leader of opposition. Okay, because we have seen that in the past, in the 16th and 17th Lok Sabha, 2014 to 19 and 2019 to 24, we did not have leader of opposition. Okay, so that is there. The leader of the largest opposition party having not less than 1/10 seats, that is 54 of the total strength of the Lok Sabha, is recognized as the leader of opposition. Okay, in 2014 to 19, Congress has 44 seats, and in 19 to 24, they had 52 seats. Okay, that was less than 54, and that is why they did not have leader of opposition. Now he or she will provide for the constructive criticism of the government policies and provide an alternative government. Alternative government will be provided by you can say a leader of the opposition. That is why it is also called as the shadow prime minister, or the, you can say, shadow cabinet can be there, because there is a leader who can, in event of resolution of the Lok Sabha, or in the event when there is no confidence, etc., at that point of time they can provide for an alternative. Okay, the leader of opposition in both houses were accorded statutory recognition in 1977 and are entitled to the salary allowances and the other facilities equivalent to the cabinet minister. So order of precedent, you know that, so order of precedent also, if we see, so they will be having a 7th number, okay, and that is equivalent to the cabinet minister. Now moving further, the office of the leader of the opposition is not mentioned in the constitution. Now this is also not mentioned in the constitution. He will be a member of crucial committees such as public account committee, public undertaking, estimates, and also a member of several joint parliamentary committees, okay. He is entitled to be a member of various selection committees when we are talking about various offices which are independent, okay. So in such cases there will be appointments which is done by president in certain cases, and there is a select committee for that, okay, and that he will be the part of that particular select committee. Here you can say appointment of the you can say heads of the statutory bodies like the Central Vigilance Commission, the Central Information Commission, CBI, NHRC, Lokpal. Other than that, recently Election Commission of India, because recently a new law has been passed, and in that there is another select committee in which there will be Prime Minister, leader of opposition in Lok Sabha, and then there will be a union minister which is nominated by the Prime Minister, okay. So I hope that is clear. Now moving to the next part, which is related to your twin test, okay. Recently you know that there was this news articles which are related to the arrest of Delhi's CM, and then there was this bail which was granted to him for the, you can say, campaigning of the elections, and afterwards recently new case has been initiated under CBI, okay. So this section 45 of the Prevention of Money Laundering Act, which is basically talk about the bail in this particular law, okay. And then there is this twin test. So this term twin test, we will be giving more focus to that. Now otherwise, when we talk about the Prevention of Money Laundering Act, with the name itself it is clear that if, let's say, there is some kind of economic offense which has happened, okay, and that there is this trail of money which is going outside India, or you can say generation of black money, use of black money, all these matters are basically under the Prevention of Money Laundering, okay. So that is there. So let's start with the discussion over here. Prevention of Money Laundering Act PMLA 2002. The Prevention of Money Laundering Act PMLA 2002 was enacted in January 2003, because it is an act of 2002 and it was enacted from January 2003. Act seeks to combat money laundering in India and has 3 main objectives. One is to prevent and control money laundering. Second is to confiscate and seize the property obtained from the laundered money, okay. So let's say there was this particular person who has gone for the money laundering, and then from that particular black money he has earned, or you can say he has purchased certain property, so you can confiscate that particular property and seize it, okay. To deal with any other issues connected with the money laundering in India. So basically it is of a nature where there are economic offenses which are put under money laundering, okay. Now moving further, when we talk about the section 45 of the Prevention of Money Laundering Act, why specifically we are talking about this bail provision in money laundering, or the PMLA? Because these bail provisions are quite stringent, okay. It is not easy to get a bail when we are talking about the PMLA, okay. So recently even the Chief Minister of Delhi was not getting the bail, but again eventually he got it. But since these provisions are quite difficult, then that is why we are talking about it. And in that particular provision, that is section 45, we have a twin test, okay, whether there are various Supreme Court judgment which has actually come up with the idea of twin test, okay. Now section 45 of the PMLA, which deals with the bail, first states that no court can grant bail for offense under this law. Now the rule is that when we are talking about the section 45, you will see the first half of the section which is saying that no court can grant bail for the offense under PMLA. So it is rule that you will not be giving the bail, okay. But there are certain exceptions. So second part deals with the exceptions, okay. So then proceeds to mention certain exceptions. The negative language in the provision itself shows that the bail is not the rule but is an exception under PMLA, okay. So the rule is that court cannot grant bail under PMLA. Now the provision makes it mandatory to hear the public prosecutor in all bail applications, and when the prosecutor opposes the bail, the court is required to apply a twin test. Obviously since a public prosecutor has the stakes in that, so there is this compulsion that you will be discussing with the public prosecutor, and if he denies the bail, then you will go for the twin test, okay. So we will talk about the twin test. Here there are 2 conditions. In the section itself it was given that there are reasonable grounds for believing that accused is not guilty of such offense, okay. So once your government's prosecutor is saying that the bail should not be given, now court has to be objective in nature, and then they will go for the twin test. Court will ask the questions whether this person is guilty prima facie if we see, so reasonable ground is there for believing that that person or the accused is not guilty of such an offense. That is the first test. Okay. Second is that is he not likely to commit any offense or while on the bail, whether if he goes out of the jail, whether he will be able to commit any kind of offense or interfere with the you can say investigation, etc. Okay, so these are the two questions court will ask. That is basically called twin test. If the answer of this particular question, that let's say there are reasonable grounds to believe that that person cannot go has not been the you can say culprit over here, in that case you can say partially you will give the bail. And in the second question, when we are talking about he is not likely to commit, that he will not be committing any kind of offense, when the question of these two is satisfying the judge that he is not the culprit and he will not go for any kind of offense, in such cases court can grant bail. These are the exceptions which we have talked about. That first part is talking about the rule, second part is talking about the few exceptions. This is the exception. Okay, so basically court has to, before giving the bail or before denying the bail, court has to talk about these two grounds as well. Okay, so that is basically twin test which is there under the PMLA. Now moving further, the enemy agent ordinance in Jammu and Kashmir. So basically this particular topic was in news because the DGP of Jammu and Kashmir has said that if someone is basically involved in any kind of conspiracy against the country, then they must be tried under this enemy agent ordinance. Okay, why? Because the provisions of these ordinance or this particular law are more dangerous than the even UAPA. Okay, so that is when we are talking about the UAPA, that is Unlawful Activity Prevention Act. So when we are talking about this particular act, that is more stringent than the UPA Act. Okay, so that is why he has recommended that. Okay, so that is why this was in news. So let's talk about it. When we talk about the origin of this particular ordinance, it is called ordinance. Earlier it was called ordinance because when we talk about the Jammu and Kashmir, there was this rule of Dogra rulers. Okay, and whatever law they have made, that was called ordinance at that point of time, and that is why we call this law as also as the ordinance. Okay, so in 1970, first it was issued by the then Dogra Maharaj of Jammu and Kashmir, and after 1947 the ordinance was incorporated as a law. Okay, because after 1947 we got independence and we have started our own you can say terminologies. In that we have addressed this particular law as you can say this particular ordinance as law. Okay, in 2019 you know that there was this abrogation of Article 370. With that there were certain changes were made. Okay, so there was this you can say act, J&K Reorganization Act. Under this act there were certain laws which were repealed, there were certain laws which were of the state which were actually continued, and there are certain laws which are in work in India, or you can say in effect in India, they were extended to Jammu and Kashmir. Okay, so in that laws which were continued from the state's law, these two laws were there. That is, one is basically you can say J&K Enemy Agent Ordinance, and other than that there was this Public Safety Act as well. Okay, and there are certain laws which has been extended from India to Jammu and Kashmir, which are related to the you can say prevention of atrocities among SC/STs. And then when we talk about the reservation laws, these were certain laws which has been extended. Okay, so that is about the history and how these ordinances are now converted into a law. So all these things are there. Now moving further, who is enemy agent? So any person who is part of a conspiracy against the country, okay, and there is a threat to the you can say defense and security of the country, such person, if he is part of the you can say a plan by the enemy or any kind of conspiracy, that will be called enemy agent. Okay, anyone who conspires with another person to carry out an act intended to aid the enemy. Okay, now trial under the ordinances. When we talk about this particular trial under this particular law, so you will see that there is a special court or a special judge will be appointed. Okay, so a special judge will be appointed. Who will appoint the judge? That government will do. Government will appoint this particular judge, and there is this provision that the accused cannot have the facilities of lawyer. He cannot consult with the lawyer until unless court provides for it. Okay, court provides for the permission for it. Okay, so here you can say that even the principle of natural justice was not followed, because the nature of you can say activity is like that. Okay, appointed by the government in the consultation with the High Court. Okay, so this special judge will be appointed by the government. Accused cannot engage a lawyer to defend herself unless permitted by the court. Then punishment, if we talk about, these punishments are even stringent over here: death or rigorous imprisonment for life, with rigorous imprisonment for life for a term which may be extended to 10 years. Okay, and then shall also be liable for you can say fine. So there are 2-3 kind of punishments. One is, you can say, death. Second is life imprisonment, or up to 10 years also, and then there can be fine. Okay, so that is about, you can say, the punishment and other provisions. Appeal against the verdict. So if we talk about the verdict of the court or the special judge which has been appointed by the government, you cannot go for the appeal against that verdict, but there can be a review. Again, that review will also be done by a person who is appointed by the government itself. Okay, here you can see there is no provision for the appeal. Decision of the special judge can only be reviewed by a person chosen by the government from the judges of the High Court, and the decision of that person shall be final. Okay, so that is there. Bar on the ordinance. Now when we talk about this particular ordinance, there is one, you can say, some bar or some caps has been put over there that is related to whenever this trial is going over there. So without previous authorization from the government, any information cannot be disclosed or published. If you are going for the publication of such information without the permission, then you will also be conducting a felony, and you might also be punished with an imprisonment of nearly 2 years. Okay, so that is about your discussions with respect to all these topics. Now we will go for a small quiz, a test, where I'll be asking the question. You can reply me in the comment box. Okay, so let's start with the first one. Who acts as the Speaker of the Lok Sabha when the office is vacant or the Speaker is unavailable? Options are Deputy Speaker, Prime Minister, President of India, Chief Justice of India. Very easy question, we have discussed about it. Okay, so you can give me the answer in the comment box. Okay, now moving to the second one, that is basically consider the following statement regarding the leader of the House in Indian Parliament. The leader of the House is the parliamentary leader of the party or the coalition with the majority of the seats in the Lok Sabha. Second statement is the leader of the House is appointed by the President of India upon recommendation of the Prime Minister. Okay, you have to choose the correct statement over here. Okay, so you can reply me in the comment box. Now moving further, question number 3. Consider the following statement regarding the criteria for the recognition of the leader of opposition in Lok Sabha. First is the party must have at least 10% of the total strength of the Lok Sabha. Second is the leader of opposition is appointed by President of India. Which of the statements given are correct? Okay, so you can go through these two statements and then you can reply me in the comment box. Okay, you have to choose the answer from these options which are given. Under the Jammu and Kashmir Enemy Agent Ordinance, an enemy agent is defined as any foreign national residing in Jammu and Kashmir, any individual who is suspected of aiding or acting on behalf of enemy country, any local resident involved in smuggling activities, any person holding dual citizenship. Okay, so you can attempt this question. Now last question, that is basically question number 5. Which section of the Prevention of Money Laundering Act 2002 deals with the twin test? Section 8, Section 13, Section 45, Section 56. So you can answer me in the comment box. With that, I would like to take your leave. I'll see you in the next episode, and if you have not subscribed the channel, please subscribe it. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.